Hi folks, my name is Greg McLawsen. I am the Affidavit of Support lawyer. I help green card holders enforce the Form I-864 in federal lawsuits, and I serve as a consulting expert in family law cases when the Affidavit of Support is enforced there. One question that comes up far too often in these cases is whether a VAWA petition hurts your ability to enforce the Affidavit of Support. It's important here to distinguish between two different types of VAWA petitions. There's the I-751 and the I-360. Let's talk about the difference between those two. When you adjust status or get a visa based on a marriage of 2 years or less in duration, so we're talking about a relatively new marriage, you get something called conditional residency status. Sometimes that's simply referred to as a 2-year green card, because when you become a conditional resident, you will see on your card that the card's expiration is 2 years from the date of issuance. At the end of that 2-year time frame, you have to file the Form I-751 I-751 petition. The purpose of the I-751 petition is to remove that conditional status that's attached to your residency. The way this normally goes is that you and your spouse file it together. If the marriage has fallen apart, however, there is a provision, and it comes from the Violence Against Women Act, VAWA, that allows you as the green card holder to file the I-751 by yourself. That is without the assistance of your petitioner. If you do that, people often refer to that as a VAWA petition, because again, the reason you are allowed to do that without the spouse's participation, that comes from VAWA. That is importantly different, however, from the second type of petition, which is called the I-360. The reason the I-360 is used is if you are not a resident already. So remember, with the I-751, you have conditional residence, and you're just removing the conditional status attached to your residency. For the I-360, you are not a resident yet, and you are self-petitioning to gain residency status. The I-360 is also based on abuse by a U.S. citizen, but the difference is that you're not already a resident. When it comes to the I-864, this is a really important distinction, because for the I-751, that's necessarily a situation where you have already gained residency, albeit conditional residency, based on the petition of a U.S. citizen or resident. So in that original process that the citizen initiated, that's where the I-864 was signed. It remains enforceable even if you have to go through the I-751 process by yourself. There's nothing about the I-751 process that terminates the Affidavit of Support. So that's actually really common for my clients, that they will be speaking to me at the same time that they're dealing with removing their conditions and filing an I-751. And sometimes they're worried if doing that destroys their rights under the affidavit. The answer is no, it doesn't. And even years later, after filing that I-751 waiver, you can potentially still come back and enforce rights under the Affidavit of Support. The I-360 is different because in that situation, the person has not gained status based on marriage to a U.S. citizen. The I-360 typically comes up where maybe the couple's married. They might have even started the marriage-based immigration process, but they haven't completed it. And if you haven't completed the process and you haven't become a resident, your rights under the Affidavit of Support have not come into effect yet. Because rights under the affidavit, those start when you gain residency based on an application that included the I-864. We've got too many forms here, I can't keep them straight. So bottom line, I-751 petition is not a problem when it comes to enforcing rights under the I-864. The I-360 is different because that is a residential status once granted that is not based on the petition of a U.S. citizen. If you are confused and you don't know which of these you might have filed, maybe somebody prepared the paperwork for you, this is something we can always straighten out either by talking to your immigration lawyer if you had one, or we can always just request your alien file, that's your immigration file, from USCIS. So if you filed something that you remember was a VAWA petition, can't remember which one it was, don't worry. That's something that we can help you sort out. Hope this is helpful. If you have questions about the I-864 and how to enforce it, feel free to drop into the comments. If you have the need for an individualized case assessment, feel free to reach out to us. We do video consultations all across the United States.